Next case we take up is 11 CE 1943. Everyone present will be giving testimony. If you'll raise your right hand.
The first thing I'm going to do is object to being forced to compel to testify against myself. I have the right against self-incrimination, and your statute 162.07 says you will take testimony from witnesses, but I do have the right against self-incrimination because I want to make a record of this cause. I will take the oath and testify to create that record, but I would ask, I'm making the objection for purposes of appeal, but I would ask that my learned opponent, Ms. Beal Hill, is the prosecuting attorney, also take the oath so that everything she says, as a matter of fact, is the truth, and everything she says, as a matter of law, is the truth.
Well, she's not required. She's not giving testimony.
I'm not.
And also, she's an officer of the court, which means that she's compelled to be truthful to any tribunal. So,
Okay.
I give testimony all the time in court, and the judges make note of that. So she's not giving factual testimony.
I just wanted to make that point.
All right, your objection is so noted. Okay, so if we can have all the witnesses raise their hand to be sworn in.
Do you solemnly swear or affirm to tell the truth in your testimony before the special magistrate?
Yes, I do.
Please state your name for the record.
My name is Scott Cutler.
Eric Addington.
Thank you.
Okay, we're here on environmental case 05QB-2334, which is a citation for violation of Florida statutes 31.0065-4U adopted by Brevard County. The statute requires an owner of an aerobic treatment unit to maintain a current maintenance service agreement with an aerobic treatment unit maintenance entity permitted by the department. It's my understanding that the respondent does contest this violation. Is that correct?
I contest the statute in question is unconstitutional on its face.
Okay. I did receive, just for the record, I think it was yesterday or the day before in my office, an email transmission of a motion to dismiss and statement of affirming defenses, which I assume is your legal argument?
Yes.
Okay. Unfortunately, we don't do motion practice in these hearings, so I'll just take that as your legal argument and essentially a statement of affirming defenses, but we don't have motion practice on this. So I think what we'll do is let me have the county put on the factual testimony of why they believe this violation exists, and then we'll get into your factual dispute, and then we can deal with the law at that time. County ready to proceed?
Yes. What's the nature of the violation on the property, Mr. Addington?
Failure to obtain a maintenance service agreement for the approved maintenance entity.
And what requires an individual to have a maintenance agreement from an approved entity?
Statute 381.065
Okay. Is the maintenance agreement the only issue?
No, the operating permit is also expired.
County Exhibit A is the expired operating permit, which appears to have expired in July 7th, 2011. County Exhibit B is the notice of violation, which was issued to Mr. Cuthbert, which he signed on July 18th, 2011. County Exhibit C is the notice of hearing, which reflects today's date, 9/15/2011, which was received and signed for by Mr. Cuthbert. County Exhibit D is the special warranty deed for the property that reflects Mr. Cuthbert as the owner of the property. County Exhibit E is the affidavit of non-payment for environmental health permit signed by Mr. Addington and done on September 14th, 2011. At this time, the county moves to enter Exhibits A through E into the record.
Okay, I'm going to have the sheriff's deputy show these to the respondent. Let me know if you have any legal basis to object to the admission of these exhibits.
Okay, this affidavit is signed by Mr. Addington. Is he
Yes.
present in court?
Yes, Mr. Addington.
You're Addington? Oh, sorry. And Mr. Name.
Take your time. Okay, I'll receive county's exhibits A through E. Any further testimony of this witness on behalf of the county?
Mr. Abington, what does the respondent need to do to bring his property into compliance?
He needs to contract with a registered maintenance entity for the unit that he has, the treatment unit that he has.
I'm sorry, you're not speaking into the microphone, I can't hear you.
Pull a little closer.
He needs to contract with a maintenance entity that's registered to work on his system. And through that, he'll be obtaining the operating permit and the maintenance requirement.
And what are the reasons for the requirements for a maintenance agreement and permit?
Well, aerobic treatment units are sophisticated systems that are unlike standard septic systems, which are usually passive. Septic systems are more of a passive nature. Aerobic units involve pumps, electricity, wiring, panels, filters, a lot of things that need maintenance and need ongoing maintenance, unlike the standard septic system. If you like, I'll tell you that this system was put on in order for the house to be built. It was agreed, whoever built the house agreed to put this system in. I don't know how he purchased it, but it was there when he purchased it.
No further questions.
All right, you have questions of the witness?
I do.
Okay, please proceed.
Okay. I just want to review something here.
Take your time.
Okay, the last inspection was performed by Scott Baumann. That's what it says on the notice of violation.
I can't confirm that at this moment because I don't have the paperwork to be able to
Well,
tell.
the notice of violation dated July 18th, 2011 says Scott Baumann.
He's most likely, yes.
Okay,
I
is he
don't
present?
know. No, he's not. The
If
violation.
he's the one that did the inspection, shouldn't he have been called as a witness by the prosecution to testify?
Special master, no man.
Go ahead.
The violation is for not having the maintenance entity. It has nothing to do with an inspection.
That's right, it has nothing to do with the violation you charged, but I would like to ask him if my system is in normal operating condition, because you're not citing me for for something that says my ATU does not work. You're citing me because I have refused to purchase a contract from a private party to inspect and maintain my system, correct?
As per Florida statute, that's correct.
Right, as per Florida statute. And it's my contention that statute creates an individual mandate that is unconstitutional, and the statute must fail. Okay? That's my...
Unfortunately, this isn't the venue for that.
Excuse me, how can I get fundamental due process if I can't present my defenses that the statute on its face is unconstitutional? I will agree that this magistrate's hearing does not have the subject matter jurisdiction to hear this cause. And if you didn't like the Keyhaven complaint, the Keyhaven case that I stated in my motion, you can also go to Orange County versus Wilson.
Okay, but at this point in the proceeding, we're dealing with facts.
Okay,
So
all right.
we'll get into argument. If you have questions for him,
Yes, I do.
go ahead. Let's do that first.
I don't know how you want to do this. I don't want to deviate from the exhibits as I've attached them to my,
Well, at this point in time, we're on the county's portion of the case.
and I understand, but I
Now,
have some
you can
exhibits
agree
that
not to question him now and call him as your witness if you want.
Okay.
Then we'll move into your case.
Here's a list of authorized maintenance entities.
Okay, but let's first finish with the county's case. Now, do you have questions for him? That's all I'm trying to...
All right, I'll let the county proceed with this case, and then I'll go in order if I get to have him reserved for a witness.
Okay,
that I
so
can
then, it's so noted that you're reserving to call the inspector later in your portion of the case. Does the county have any further evidence?
No, sir.
Okay, so the county is done with their portion of the case at this time. Now we can move into your case. Tell me
Okay.
what you want me to hear.
What do I want you to hear the fact that what I just said, this case is prosecuted on the fact that I don't have a maintenance contract with a maintenance entity, that I believe that law is unconstitutional. Now I would like to enter my exhibits.
Put together a pack of your exhibits, and I'll have the sheriff's deputy hand them to the county and see if the county has any objection.
Some of those I'd like to enter as composite exhibits because they're multi-page.
Are they all numbered?
They're lettered, exhibit A through
Okay, that's fine.
G.
We're gonna have the sheriff's deputy.
Okay, we're gonna keep those with the file.
I understand, I have a copy of them, I was told that I had to submit the originals, so to the best of my ability and knowledge, those are the originals. Okay, that exhibit A was on my front door on July 14th, is when I found it.
Exhibit A. All right, let's do this first. Before we get into your testimony, let me see if the county has any objection. If not, then we'll just move those in as your response exhibits A through
Chief.
G. Okay.
So there's a copy of those. No objections.
Okay, we'll receive that as county's, or I'm sorry, respondents exhibits A through G. All right.
Okay, I just want to clarify one thing, you are going to make my motion, even though you don't consider this hearing procedure to, I mean, you don't want to accept my motion because this doesn't do motion
No,
practice.
we don't do motion practice, but in essence, your motion is substantive argument, which I'll.
Okay, and it will be made part of the record of this proceeding?
Correct,
Oh.
correct.
Okay, you want to attach that as Exhibit H then? As
Is
I
it already
filed,
an
or
exhibit, or is it in the file?
is it-
It is in the file, it hasn't been marked as an exhibit. If you-
Okay,
if
yeah,
you
we'll
wanna
mark
move
this
it into
exhibit.
evidence,
What, you want to
that's
call that
fine.
H?
Yes, I would, I'd like that pleading to be. And I would like to note my objection that you refuse to accept it as a motion to dismiss.
No, we just don't do motion practice. In essence, these are legal arguments, so I'll receive it as your legal argument.
That's fine.
All right.
Okay? So I got the notice of violation, that's Exhibit A.
Okay,
I got the demand for payment for the maintenance contract and the cost of the operating permit from Brian Davis Septic Systems. He demanded $50 for the county fee biannual operating permit for ATU/preferred based treatment systems is $50, and the additional $100 for the on-site treatment disposal system, the ATU, for a total demand of $150 for the fees. And then received as Exhibit C, the $300 demand for the maintenance, the cost of the 2-year maintenance agreement.
okay,
I would like to note, make sure that it's on the record that Brian Davis Septic Systems is a private third party.
okay.
When I bought this property, I can find no provisions of law that require any type of pre-sale disclosures of the cost of ATU maintenance. And what you have, and that you're required by state law to buy the permit in the operating maintenance contract. I've never had a problem. I've lived in Florida for, since 1960, except for a year in Texas. And 30 plus of those years have been on properties, residential properties with septic systems. Never had a problem except having to have a black water tank pumped out one time. So when I bought my house, You know, when I was told I had an ATU, I had no problems with that because nobody said it's gonna cost you $450 every 2 years for a maintenance agreement and an operating permit, and nobody told me that, you know, the system was reduced from 2 1,000 tanks, a 1,000-gallon Blackwater tank and a 1,000-gallon gray water tank, down to one 500-gallon tank, which I don't think is fit for its design and intended purpose, simply because it's not big enough to handle the load.
Okay.
Shortly after I moved in, I started receiving demands from a guy in St. Cloud wanting to charge me for the maintenance agreement and operating permit, and I thought it was a scam. Then I started receiving them from Brian Davis Septic, and I thought it was a scam. I didn't realize that it wasn't a scam until Ray Walton inspected my system and left a note. Actually, I talked to Ray the day he inspected my system, but then I responded to Exhibit E, which was a notice of non-compliance, telling me that yes, if I didn't buy the thing, I would have to face this administrative hearing, and this was back in 2009, and be subject to fines up to $500 a day. Then I realized it wasn't a scam, you guys were serious. Shortly after I felt coerced and intimidated and threatened into purchasing the $450 total cost package from Brian Davis Septic. And he said shortly after that he inspected my property on July 5th, which was a Sunday of 2009. And I got an estimate in the mail, or a proposal in the mail, and he was telling me that he needed to replace the air filter in my blower pump and to reset the alarm panel. There's a mechanical alarm panel associated with these things. And he wanted $395 to perform that service. I thought that was outrageous. I found the name of the manufacturer of my system, called them, and they sold me the filters for $15.21, and they explained to me to turn the system off, unplug it, take the screw out of the top, and replace the filter. So for a total of $15.21 and about 10 minutes of my time, I fixed the problem that he wanted $395 to fix. That's price gouging. There's no consumer protections in this statute whatsoever. There's no consumer protections anywhere. At least if I was hooked up to a sewer system, they would be regulated by the Public Service Commission, and we would have some rights. Then again, I got this notice of violation, dated July 18th, 2011, certified mail, and I've attached that as G1, 2, and 3. And in that notice of violation, in your fines provision, because Brevard County has stepped up the fines under Chapter 162 from $250 a day for an initial violation to up to $1,000 a day, simply based on population, which I believe is unconstitutional on its face also, because that's a violation of equal protection, because it steps up the fine simply because of the population of the code enforcement board area in which you live. And I just think that's abhorrent and violates equal protection. And now I am subject, according to your fine schedule, you can fine me up to $1,000 a day if I am as obstinate as I am being in refusing to comply with the unconstitutional law. Now, as Exhibit I would like to enter service providers by type of unit service.
Okay, I'm gonna have the county attorney look at that, Sheriff's deputy.
And then I would like Mr. Eddington to get a copy of that.
Okay, let me find out if the county has any objection, and then she can pass it on to the inspector. If not, we'll call that Exhibit I. Respondents.
No objection.
Okay,
Oh, we need to
we'll admit
clear.
response to Exhibit I.
Go ahead, Margaret.
Mr. Addington, if you could review that list?
Yes?
Does that look accurate for Brevard County Public Records that I got from your Environmental Health Services this morning?
It appears to be. I have not personally checked this list lately, so I can't accurately say yes.
Okay, you are a supervisor for the inspector,
Yes,
is
I am.
that correct?
Yes, I am.
Okay. Do you perform these inspections also?
I have. I don't on a regular basis anymore.
Okay. Could you go down that list and tell me which companies you have actually personally received certification from as an inspector on that list?
Objection, relevance.
No, it is relevant because I've been told that I cannot do the inspections for myself unless I have been approved by the specific company that installed my system or the manufacturer of my system. And if I can't maintain it or inspect it because I'm not approved by the company, how can they maintain or how can they inspect if they're not approved by
What
the
is
company?
your question that you want to ask him?
The question that I want to ask is how many of those companies on that list has he been approved to perform inspection services?
Okay, you're saying how many companies listed on Exhibit I has this inspector been approved?
Right, there's 24 lists, there's 24 names on that list
Yeah.
of approved systems for use in the state of Florida, approved ATU systems, aerobic treatment unit systems. And I have been told by county staff that I cannot inspect or maintain my own system unless I am approved by the manufacturer of my system. The manufacturer of my system, the Alliance 500 system, won't even deal with me on that issue because they want to make money from the septic tank contractors doing the inspections and all that. So if he's not been certified, how can he inspect them if I'm not able to?
Well, if the
It's
witness
an
can
equal
answer.
protection issue.
If I could clarify the nature of the inspection, can I do that? The nature of the inspection is a visual inspection, does not require, you can do the same inspection that I do, or any inspector does, because it's not a inspection that requires approval by any of these people, any of these companies.
But the county won't recognize that as a valid inspection, will it?
Not, for us, yes. Yes,
So if I perform the inspection,
you're not qualified under the statute to do the inspection.
and that's exactly the point I'm trying to make. Are you? Have you been approved by any of those manufacturers?
It's not a requirement of the manufacturer, it's a
That it's
statute.
not a requirement of the statutes, and that's one reason it violates the Constitution, because there's no equal protection, and because the Florida law says that under JP versus State, as cited in my motion, once you choose to exercise your police power, when it violates one of my fundamental property rights, like Article 1, Section 23 of the Florida Constitution, you have to do it in the most least intrusive means available. Refusing to allow me to inspect and for that to be approved by you is a violation of my private property rights under Article 1, Section 23.
Okay, you need to stick to questions. I'll hear your argument later, but you have questions for the inspector?
I do.
Okay, please proceed. And while he's looking at his questions, it's my understanding that a property owner can get certified under the statute to do his own.
If the manufacturer will train them, yes.
Okay.
And if they're living in the home.
They're living in a home and the
They're living in a home.
manufacturer trains them, they can be certified to do their own inspection.
That's correct, and
Okay.
there is a permit fee for that.
There's a
$25
small permit fee and then what do they get, a letter from the manufacturer?
No, they have to get a letter from, and be certified from the manufacturer.
And a letter from the manufacturer saying that we certified this owner as competent to do an inspection.
No, it's not just, it's the maintenance.
The maintenance.
Inspection has nothing to really
Okay.
do with the
All right.
inspection, it's a maintenance, the maintenance of the unit.
Okay.
I would like to introduce as Jay this document from an entity called NSF, and they have an online wastewater accreditation program that costs, last time I checked, I believe, if I remember correctly, over $1,000 to become accredited, and that would allow me to maintain or inspect multiple systems, any system, and I'm presenting that as evidence that there are less intrusive ways for the state of Florida to enforce this law.
Okay, and let me see if the county has any objection to Exhibit J, or proposed Exhibit J.
I'm only going to object to relevance, but.
Okay, I'll admit it for what it's intended. I mean, basically, it's intended to say that for $1,000, you can get approved to do these maintenance, I assume.
Well, certainly, if the respondent did that, then he would be
Yeah.
certified to do it.
May I comment on this?
Go ahead.
Okay, this is an inspector accreditation for systems, for general septic systems. And I don't see on here aerobic, it may be, I haven't seen it yet. But this has to do with wastewater inspection. It may or may not include aerobic units. I don't see anything on here that says aerobic units, which are specialized units. And again, this is for inspection only, not for maintenance. This is for inspection.
Okay.
Which would not fulfill the requirement of the law.
All right. Any other questions?
If you can go on that entire website and look at it, it does have the inspection and maintenance for ATUs in there. May I ask, if you will, what is the purpose of this statute? Why do we have to have, I mean, what's the state's end goal? What's the police power regulation behind this? What's their purpose?
Well, perfect.
Objection?
Yeah, it's probably not within the purview, but as best as you understand it, you can respond.
Again, as I said in an opening statement, that these are specialized units that involve pumps, motors, filters, electricity, wiring, all kinds of sophisticated things as opposed to a standard passive septic system.
Okay,
So
let me
the state-
rephrase it, maybe this will be better. These ATUs are required to be installed on less than a half acre of land because it improves the quality of the effluent coming out of the system and to protect the groundwater supply, correct? Would that be a good summary?
All those statements are not necessarily accurate, but I understand the gist of what you're saying. This system was installed so that that house could be built where it would not have, the size or the flows of the lot required it to be installed to meet rule, yes.
Yeah, and the ultimate reason why, if you were not allowed to build on quarter acre lots unless you had one of the ATUs, the underlying reason is to protect the groundwater supply in the aquifer, correct?
That's correct.
Okay. I would like to introduce Kay.
How many exhibits do you have?
That's it.
Okay. Because I was going to have you identify them all, I didn't do it one by one, but, okay, we're going to pass this down to the county attorney to see if she has.
And while she's inspecting, if you would like to hear my reason for incorporating that?
Sure.
Okay?
And what is Exhibit K?
It's, I'm sorry. Relates to aquifer recovery, or aquifer storage and recovery wells.
Okay. Can I have any objection?
Only to relevance, no objection.
All right, I'll admit it.
The relevance is that in Rockledge, they have, if the ultimate intent of the state's exercise of police power for chapter 381.0065, paragraph 4, subparagraph U, is to protect the groundwater supply, then why has the state seen fit to issue the city of Rockledge and the city of Cocoa Beach has an application pending to pump 200 million gallons of septic into the groundwater supply, poisoning all the wells within a mile diameter? Because if you look at this,
Yeah, I mean, I'm going to admit it into evidence, but it really doesn't
because if
deal
you
with our
look,
facts.
if you look at the pictures where it has, in the city of Rockledge, reclaimed water used for irrigation, do not drink, they poison the wells in Rockledge within a mile radius. And if this-
Objection to the characterization.
that's, the state issued the city of Rockledge the permit. The city of Rockledge pumps 200 million gallons of treated sewage into the ground a year. The wells have been poisoned for a mile radius. The city of Rockledge has posted those signs to let people know they can't drink their well water.
Okay, anything else you need me to consider?
That was pretty much the record I wanted to create, and then I would still like to reserve the issue, you don't have the subject matter jurisdiction.
Okay, we all have, all the exhibits are in. Do you have any further questions of this witness?
Yes, I do, actually.
Go ahead.
When my property was inspected, we had this phone conversation, we had this conversation on the phone. Does the county and your department get the inspection warrants required by Camaro versus the city of San Francisco, which is a United States Supreme Court ruling that says the county and cities and municipalities can't do blanket inspections without inspection warrants, and because it violates the Fourth Amendment to the federal Constitution against illegal searches and seizures. And Florida statute 933.20 inspection warrants requires you to get inspection warrants before you perform an inspection. Do you get those, before you inspect a property, do you get the homeowner's consent, or do you go get an inspection warrant?
We're not required to get an inspection warrant because we have right of entry under the statute. No, we don't go get a warrant before we do an inspection.
Bear with me, Mr. Magistrate, just
Go ahead.
one second. Florida statute 386.0065, paragraph 6, enforcement, right of entry, citations, says, as used in this paragraph, the term premises, which the legal definition under Black's Law Dictionary is the land and the buildings thereon, does not include a residence or private building. To gain entrance to a resident or private building, the department must obtain permission from the owner or occupant or secure an inspection warrant from a court of competent jurisdiction. So what Mr. Addington just said is that he's got the right of entry is perjury.
Well, he's
Well,
not
I object.
he's not testifying to facts. I
It's
mean,
not into a building.
no, it's, his interpretation of a statute is not perjury. I mean, so let's move on.
Wow. If there were, based upon that statement, if there were a procedure for me to ask you to recuse yourself, I would. But under Chapter 162, there's no procedure, because now I have no faith, hope, or confidence that you're going to give me a fair and impartial decision.
You're going to get a fair trial, but you need to proceed. If you have a fact question for the witness, ask him. We'll get into argument.
I asked him what gave him the right to enter my property without an inspection warrant, without my consent. And he said he's got the right under the statute to do it. And I just read you the statute that says he does not have the right
You
to
can
do it.
ask him about his inspection if you want, but don't ask him about what the statute does or doesn't do. If you have a question about his inspection, ask him.
Okay, how's this? Mr. Addington, do your inspectors ever obtain prior consent before they inspect?
Yes.
They do.
Yes.
Not for me.
Okay. Did you ask me, do we ever do it? The answer
Okay.
is yes.
On a regular basis, do you do that?
No,
Why not?
because under our reading of the statute, we don't have to.
Well, why don't you tell me how the inspection took place? Were you there at the house?
No, I was not. I was not. I came home and the notice was on the door that we were here and inspected.
So what are you saying? That while you were gone, your house is locked, the inspector snuck in?
While I was gone, the inspector came and entered my premises and performed an inspection without my consent or a warrant, an inspection warrant.
Okay, were you personally there? Did you see this?
He left his little notice on my doorknob saying I was here to inspect today.
Okay,
And that's admitted as part of the record,
all right, so noted. All right.
okay? That's pretty much it. I have no further questions.
Okay. County, have any further testimony?
No, sir.
Okay. So we're done with the fact finding portion. Now, if anyone has any, does the county want to make brief closing or argument, and then I'll hear from the respondent.
Only that, as the respondent noted in his brief that he submitted, and he's stated here, deciding the constitutionality of a state statute doesn't fall within the purview of a special magistrate proceeding. I appreciate Mr. Cuthbert's arguments, and I look forward to the next level. However, today, you simply can only rule on whether or not he's in violation of the county ordinances and state statutes as they stand today.
And you're referring to his arguments on page 5 of his motion, paragraph 13.
Yes.
Okay. Anything further from the county?
No.
All right, let me hear from the respondent.
Okay, even though Florida Statute 162 says that these procedures are supposed to be held in compliance with fundamental due process, if I'm not allowed to present my defenses as to the constitutionality of the statutes that I'm charged with, those arguments are irrelevant, and I am going to be found liable, and if I want to further pursue this issue, I have to appeal. You're going to subject yourself to further litigation at my expense, because this hearing and this proceeding doesn't have the jurisdiction to hear my case. Am I missing something?
All right, I mean, tell me what your arguments are. I'll be glad to listen to them.
My arguments were all in writing.
Okay. All right.
But I do have one other little thing that I want to present. If the Key Haven case isn't enough to convince you that you don't have the jurisdiction to rule on this matter, in Wilson versus the County of Orange, 881 SO2D 625, Florida District Court of Appeal, 5th District, 2004, which is the governing jurisdiction, which makes their opinions controlling precedent. In the section entitled Failure to Exhaust Administrative Remedies, the 5th District said it is well established that the facial constitution of a statute cannot be heard in an administrative proceeding. The case of Orange County versus Wilson was brought about when the Wilsons lost their code enforcement hearing and then lost in circuit court. And when they appealed, they had filed everything under violations of the civil rights, the federal civil rights statute under Title 42, Title 42 United States Code Section 1983. And I'm pretty much, if you act ultra vires, whatever limited qualified immunity everybody is may be entitled to, that will be pierced by what I view as malicious prosecution. And now that you know that I am making these allegations as to unconstitutionality, and the federal 11th Circuit Court of Appeal in the case of State of Florida versus Department of Health and Human Services and Kathleen Savias just upheld the finding by Roger Vinson of the Federal District in the Northern District of Florida that the individual mandate requiring individuals to purchase expensive products or services from private third parties was unconstitutional. The 11th Federal Circuit Court of Appeal held that the individual mandates were unconstitutional. That is exactly what this statute requires, and I can't believe The Key Haven decision said that I shouldn't be subjected to the expense of an administrative hearing because you don't have the authority to rule on the issue. That's what Key Haven said. Now you're saying that Ms. Beal Hill is welcoming me to the fight at the circuit court level on appeal? That's just trampling my fundamental due process rights completely.
Okay, anything further?
No, I'm just astounded.
Okay. Anything further, you want me, you've done a very lengthy, and I appreciate the energy and passion you exhibited in doing this motion.
Okay, well, then, you know, I was going to save this for appeal, but I will bring it out. And the one thing I did forget to mention, in the notice of violation, Mr. Baumann told me that I would be subjected to criminal or civil court proceedings.
All right.
162 doesn't allow for criminal proceedings. It does, and that's a threat. That is the coercion. That is what makes it involuntary servitude in violation of the 13th Amendment to the federal Constitution. And the $1,000 fines Brevard County is authorized himself to charge. In the case of Amos versus Gunn, 94 SO 615 at head note 24, page 617. And in the body of the case, it's page 641, the Florida Supreme Court said that if a fine is so great or numerous as to intimidate persons in asserting their rights to test the validities of laws or regulations which they may be required to observe, they are therefore denied due process and equal protection, and that is the Florida Supreme Court. So,
Okay.
I'm going to guess now I rest my case.
All right. Now, I think you've argued it with a lot of passion, a lot of effort, a lot of thought. And, you know, I've had this issue come up many, many times over the years. It's not novel, it's not unique. Chapter 162 says that essentially I have a fact-finding mission to determine two things. One, is there a violation of the particular code or statute? And two, sometimes I have to interpret what the language of the code or statute, those two things. That's why it's quasi-judicial. I have no authority to rewrite a statute. The legislature does that. I have no authority to declare it unconstitutional. That's just, Chapter 162 doesn't put that in my list of things to do. So,
how am I supposed to get fundamental due process then?
well, you know, you can appeal this, but the issue on appeal, I'm not your lawyer, the issue on appeal will be the facts. You won't even have the ability to, in my opinion, to argue unconstitutionality on appeal. You'll have to file a debt judgment for that, declaratory judgment action. And the only one that's going to be able to determine if this statute is constitutional or not is a circuit court judge, and that'll go to the Supreme Court. And there's certain procedures that have to be involved before a statute is declared unconstitutional. But the procedure doesn't start at this hearing. It's a separate thing. So, you know, it's kind of like if you follow Major League Baseball, you hire an umpire to call strikes and outs. And he's given a set of rules. He's not given the right to say, all right, I think the pitchers are ahead of the batters. You can get 4 outs now before you're out. You can get 4 strikes. That's not what he does. He calls strikes and outs. He calls it like he sees it. That's what I have to do here. And it's very simple. The factual issue is, did you have a contract to inspect and maintain the system? And it's clear from your statements and from the inspector that you didn't. And I am not here to determine if that statute is wise or it's full of folly or if it's unconstitutional. That's not my prerogative. So you're right. In paragraph 5 of your brief, you're right. I have no jurisdiction to do that. And the legislature saw fit to, and legally so, to say, basically, I'm a fact finder. I'm not here to judge constitutionality of any statutes. I mean, and this is not the first time this has come up. It's come up many, many times. So
You have to have jurisdiction before you can make the ruling. And I'm asserting you do not have jurisdiction because you can't hear my defense. And you just admitted you can't hear my defense.
I cannot rule on constitutionality of statutes. I can determine facts, which I will do this morning.
Okay.
And basically, from what I've heard on case number 11 CE 1943, I will find that there has been a violation established by the county at 381.00654U which requires the owner of an aerobic treatment unit to maintain a current maintenance service agreement with an aerobic treatment unit maintenance entity permitted by the department. The facts before me have established that that has not occurred. And I don't know whether the county has any other, normally on cases like this, I give you 14 days to cure it, $25 a day fine, and I award the cost. Typically, it would be $550. And I don't know whether the county has any.
There's no reason, the county has no reason to ask for anything different.
Yeah, that's typically how I do this. And, you know, it's your prerogative how you want to handle that constitutionality issue. I think before you do anything, you should talk to a lawyer, because there's a lot of procedural steps you have to go through. It's not just popping and filing a lawsuit. There are certain notice provisions you have to do.
Well, I understand. One
It's
of them is-
fairly complicated.
And I've given you the case of Wilson versus Orange County, which says you just subjected yourself to a Title 42, Section 1983 civil rights lawsuit because you just thrown your qualified immunity out the window, because I truly believe that what you're doing is malicious, requiring me, denying me the opportunity to notice, because fundamentally, if I can't present the challenge to the constitutionality of the statute, I'm denied due process.
I understand your arguments, but you know what? You gotta find another court and another day to present those.
We'll see each other again then.
All right.
Looking forward to it, Ms. Bealville.
Thanks, Mr.
So on the case number 11, CE 1943, I will find there is a violation, 14 days to cure, $25 a day fine, and award the county the cost of $550 due within 30 days. And I think we've got all the exhibits marked, and I'll have the clerk check. Let's see, do you have, where's exhibit I? Do you have that?
Whoops. Here's, yes, yeah, over here, sorry.
And this is H. That's I. Okay, the order should be submitted within a couple of days, and you'll have a right to get another copy of that if you want to at the clerk's website.